Hey, good morning, everyone. I think we were hearing that we won the award for largest panel with the greatest number of panelists. So I thought it might be nice to go ahead and get the introduction started so that we can see everyone who's on the panel before we jump into some of the topics. I'm Melodi McAdams. I work as the Research and Repatriation Specialist for United Auburn Indian Community, and I'm co-moderating this panel with Buffy.
Hi everyone, I'm Buffy McQuillen. I'm the THPO for the Federated Indians of Great and Rancheria. I'm also very excited. We added some folks yesterday and I'm super excited by that. So welcome everybody and hopefully we have a great discussion today.
And we were hoping to go kind of in order of the way we'll be structuring our presentation. So we wanted to invite Lourdes and the members of the working group to introduce themselves first, then move on to the campuses, then move on to Heritage Commission representatives.
Great. Hi, I'm Lourdes DeMattos, and I'm at the UC Office of the President. I'm in a policy office, and my job is to get this policy going, written, and hopefully finalized very soon. And my office will also be reconvening all the repatriation coordinators and points of contacts to implement the policy. I'd like to introduce Dino. Dino was on our work group. Dino, do you want to say a few words? Dino, you've unmuted yourself, I see, but we cannot hear you. Maybe while you figure out that glitch, we can go over to Carol Goldberg.
Thank you, Lourdes. I'm Carol Goldberg, member of the UC work group, a longtime member of the UCLA School of Law faculty, sort of retired in July of 2018. While on the faculty, I did serve as the UCLA repatriation coordinator or repatriation committee chair. And I also served as UCLA's representative on the system-wide repatriation committee. I'm delighted to be part of this program.
Thank you, Carol. Michele, do you want to introduce yourself?
Hi, this is Michele Fahley. I'm in-house counsel with the Pechanga Band of Luiseno Indians. I'm also trying to manage a court call case in my ear right now, so sorry if I'm a little scattered right now. Of course, this is perfect timing on the court's part. So anyway, I was assisting Chairman Maccaro by working on the UC policy work group and on his behalf, especially once COVID really kind of took over our life. So I've been working in that role with the UC NAGPRA work group, as well as, using my own comments and thoughts as in-house tribal counsel to help move the policy along. And also, I was, one of the technical advisors on the Gloria bill. So, I definitely would like to maybe tee this up and talk about, what was the intent, what were the things that the drafting team was trying to address. I think that might be, some good background for the rest of our discussion today. So I look forward to having the panel. Thank you.
Thank you, great. And Dino, did you fix your technical glitch? Yeah. Okay. Well, Dino Beltran from the Coyle Nation was also on the work group for this process. So next we can go to the campuses. Berkeley campus. Tom.
Hello, my name is Tom Torma. I'm here with my cat, who I've been asked by Shasta to introduce. She gets very loud if she doesn't get her way, so expect to see this tail. And you'll see a 17-pound cat. She's 7 pounds. You'll see a 17-pound cat in the background that she completely bosses around. So I am the NAHC liaison for UC Berkeley, based out of the Vice Chancellor for Research's office. And I just want to thank everybody for having me here. Thank you.
Thank you, Tom. Very excited to have Tom on board. He's fairly new and we're very excited to see that shift. Davis, Megan.
Morning, everyone. My name is Megan Noble. I'm the NAHC Project Manager for UC Davis. The NAHC project is based in the Office of the Provost. And thank you to Buffy and Melodi for putting this panel together. I'm looking forward to connecting to everyone today.
And Wendy Teeter from UCLA.
Hi, everyone. I'm Wendy Teeter. I'm the Curator of Archaeology for the Fahley Museum at UCLA. And I'm the Repatriation Coordinator for the campus. And I also teach in American Indian Studies and sit on the UC Office of the President Native American Advisory Council. Thank you.
Thank you. I think that's all from our side. Tim Miller from my office is an analyst and who's also been helping me in these efforts, might come on at some point. So I just want to let you know who he is. It's from the UC side, Melodi.
Thank you. And I apologize. I realized that I got a little bit out of order and I didn't ask Courtney Coyle to introduce herself. So I apologize, and please go ahead and introduce yourself.
No worries, Mel. Good morning. Good morning, everybody.
Good morning.
I'm Courtney Coyle. I'm an attorney in private practice, and I am outside counsel for United Auburn, and I was a technical advisor on AB 275 and also AB 168, which we hope to just do a quick touch on, even though it's not a repatriation bill. So thank you.
And do we have the members of the Heritage Commission? Well, great. Let's turn it over to them for their introductions and then get into the subject.
Hi. Good morning, everybody. So good to see all of you. I wish we were in the room together. That would be amazing. My name's Miranda. Greetings. I am zooming in from Tongvaland in downtown Los Angeles. So I'm here today to be involved in both the morning and the afternoon panels, probably speaking more in the afternoon panels about the NAHC's role with repatriation and the newly signed into law, AB 275, yes. And I was also technical advisor on AB 168 with Courtney, and was actually technical advisor on the original, way back in the day, I think it was 2001, original CalNAHC bill. And I am serving currently as chair of the Native American Heritage Commission and have been on the commission for over 10 years. Wow. I'm excited to be here, looking forward to assisting in any way that I can and hearing from everybody and letting you all know where we are in implementation on this. And we have also Merri Lopez-Keifer, who is Commissioner and Secretary with the NAHC. Go ahead, Merri.
Okay. Miliam, everyone. Hello, good morning to everyone. I want to say thank you to the organizers of the event, the THPOs, the SHPO, as well as the Paula Band and Mission Indians for hosting. And I'm excited to be on such a large panel, but with so many powerhouses of knowledge. I am not a technical expert, or I gave no guidance to any of these bills, but I'm happy to be here in my role as a commissioner for the NAHC. And I am looking forward to the discussions that we're going to be having. So thank you, everyone, for allowing me to be a part of it.
Oh, and I guess I also just want to say that there's a lot of UC grads here too. And I'm a UC grad, UCLA alum. So I don't want to think of it as sides that we're on. I think we're all here for the common interest, and we're all here to pursue something that's all very near and dear and a crucial part of either our profession or our heritage and our identities. So I just wanted to put that out there too.
Absolutely. I'm sorry that I said it that way. Common goal for sure.
If I may, I also wanted to share that I'm the vice chair of the UCOP's Native American Advisory Council. I'm honored to be a part of that process as well. And I am a member of the San Luis Rey Band of Mission Indians, which is a non-federally recognized tribe that's on the contact list for the NAHC. Yeah, I think that's it. All right, thank you. Oh, go Gauchos, UC Santa Barbara.
Excellent. Thank you. Do you want me to just jump in, Melody? Do you want me to go?
Yeah, just 1 second. So I was wondering if any of our working group representatives who weren't able to introduce themselves earlier have gotten on Dino. Oh, so our panel is really long. If you haven't looked at the agenda, we are scheduled to go from 10 to 2 with a lunch break in between, and we really do have that much material. So we're going to start it off with a discussion about AB 275 and 168 that Courtney will kick off and that I'll chime in on as well. And then we'll move into a discussion of the UC system-wide repatriation policy and where it's at, then move on to the campuses, and then transition to the Heritage Commission. So we've got a lot of different subjects. We will be breaking after each of those subjects for a lot of question and answer and a lot of discussion. So I was hoping to turn it over to Courtney to get started on a discussion of AB 275 and 168.
Okay, thank you, Mel. Coming to you from beautiful San Diego, Kumi Islands. It's a wonderful warm day down here. So United Auburn, like I said, was the bill sponsor starting this year. We kind of inherited this bill. It was a 2-year bill. And we're so very pleased that the governor signed it. It's a Ramos bill last Friday on California Indian Day. He kind of did a package of actions. So this is all very new to everyone, hot off the press. I've put a link to AB 275 inside the chat box. So if you want to follow along, you can do so. Mel and I are just going to do some quick hits on the bill to try and set some context for today and some definitions, because there are some important new or updated definitions for CalNAGPRA that I think are going to be very good. And we wanted to get you excited so that if you haven't, you actually go and open up the bill and read it for yourself and see what there is in there that might be able to help you and your tribe's efforts to achieve repatriation. A little spoiler alert, I think there are some Easter eggs in the bill, so hopefully you will agree as we get there. So 275 was an effort to update the 2001 CalNAGPRA that Laura mentioned statute to do 3 things. Number 1, to better align with federal NAGPRA as amended. Number 2, to better address California-specific histories and issues. And number 3, to eliminate or lessen identified barriers to repatriation outcomes. We ran into a little chicken or the egg issue with this. As Michele mentioned, there was the AB 2836 Lagoria bill in 2008, the UC repatriation policy update, and all those great work sessions that Lourdes and her team were working on with the tribal stakeholders, and then AB 275. So they were all happening simultaneously and influencing each other, which I think was really great and beneficial. So please recognize there will be a period for harmonization and further clarification. And in Julie's words from this morning, maybe we don't know, but we will figure it out together as we implement this. But I think it's pretty exciting. So I'd like to start with our PowerPoint here. It's very brief, with highlighting some important definitions and legislative intent. We hope you'll see that there are some potential game changers in here. And this was intentional, particularly to get at some of the stubborn and recurring structural barriers to the repatriation efforts, kind of the legacy thinking that Julianne maybe talked about a little bit this morning. Well, we've always done it this way. This is how we interpret it. So this is how we're going to do it. So we tried to get at some of those. So with the first slide, please, the next slide. Shasta's helping me out because I cannot multitask anymore. So Shasta, if you could move it, I've got COVID brain. The first one is consultation. You will recognize most of the 2/3 start of the definition from your work on SB 18. But in here, it also includes consultation between agencies or museums and California tribes. It also adds in the last line there, the need to respect tribal traditional knowledge and all tribal information shared during the consultation. So this was aimed to get that definition of consultation into the repatriation process for it to be done early and often, and to really address specific treatment of information shared by tribes during the consultative process. So we think that this is a positive addition. Next. The next slide will be liaisons, and this is kind of an effort to institutionalize the professional staff within the lead agencies and kind of really embed this notion of relationship building between agencies and tribes to kind of go beyond Governor Brown's Executive Order B-1011 from 2011. As we all know, executives come, executives go, and they can change an executive order. But here now we have this liaison provision in California statute. It makes a recommendation to the regions to do this, but it does require other state agencies with significant interaction on tribal issues, people or lands, to designate one or more liaisons, right? So if there's a lot of work to be done, it doesn't necessarily have to fall on one person's shoulders. So I think that's a positive. And for the purposes of this section, state agency means a department or agency of the state, California State University, University of California, and Judicial Council of California. So it tries to be a little bit broader there. So we're excited about that provision, and hopefully that will help develop the relationships to make repatriation happen. Next slide will be tribal expertise. So this is part of the legislative intent. I'm going to read this, because I think the words really matter. So recognize that California Indian tribes have expertise with regard to their tribal history and practices that concern Native American human remains, cultural items, tribal cultural resources with which they are traditionally and culturally affiliated. And because the federal and state repatriation processes call for a sufficient degree of analysis, really important there, including tribal traditional knowledge about the land and resources at issue in all decisions related to the repatriation processes. This includes treating tribal traditional knowledge, which we'll go into the definition next, as the authority with respect to determining cultural affiliation and the identification of cultural items, so that it is given deferential weight to other lines of evidence, and saying that the TTK meets the reasonable standard that was identified in the original CalNAGPRA. So I know there's a lot in there, there's a lot to unpack. I think that there's going to be some good tools in there, that evidence really needs to be provided by the entities that are qualified to do so, which really is the tribes as the experts in their own cultures, which is, I think, a theme that we heard during the sessions yesterday. And hopefully this will be a mechanism to get beyond the instances that I think we've all encountered, where academic and scientific values were really implicitly, if not explicitly, provided greater weight in the process. So this is also when I see, the deferential weight. Maybe this will be a marker for us in other future areas of California law, whether it's CEQA. Hopefully this will make it seem less scary to the stakeholders and the lead agencies that, you know, when tribes are saying something, it's sincere and it's evidentiary and it needs to be accorded deference. Next slide is the definition of tribal traditional knowledge. You heard a little bit about this in yesterday's panel relative to the Advisory Council's efforts on the information paper, and I think that this dovetails really well with it. They didn't really say a definition because, you know, every tribe is different and they're going to allow the tribes to express that. But here is one way of doing it, and it's kind of NAGPRA specific. So hopefully this will be a marker for other statutes or other areas that tribes work in. You may need to build this or emphasize or de-emphasize parts of it. But TTK are knowledge systems embedded and often safeguarded in the traditional culture of California Indian tribes and lineal descendants, including but not limited to knowledge about ancestral territories, cultural affiliation, traditional cultural properties and landscapes, culturescapes, traditional ceremonial and funerary practices, lifeways, customs and traditions, climate, material culture, and subsistence. Again, tribal traditional knowledge is expert opinion. So if there's conflicting evidence, the deferential weight should go to the TTK. TTK alone may be sufficient to meet preponderance of the evidence standard. The standard is not changed under NAGPRA, but this definition gives a little additional California gloss to it. And I think it works really well with the ACHP's efforts. Next slide is canons of construction. And for those of you who participated in those stakeholder sessions that Lourdes and the UC Office of the President did, and as Carol will recall, we talked a little bit about this when we were talking about the UC policy. So the goal of this is to apply the state's repatriation policy consistent with NAGPRA, considering the unique history of California towards California Indian tribes and the canon of construction regarding federal Indian law with respect to, number one, laws must be interpreted as the Indians would have understood them. Number two, that the law be construed liberally in favor of the Indians. Number three, resolve all ambiguities in the law in favor of the Indians. And number four, to preserve tribal property rights and sovereignty unless a contrary intent is clearly stated in the statute. So for those who work in Indian law, right, this kind of reflects Cohen's Handbook of Federal Indian Law. It's again designed to address those all too frequent instances where there's been interpretation of the NAGPRA and CalNAGPRA statute by maybe museum specialists or others, and it hasn't broken in a way that was helpful to the tribes. And again, it kind of felt at times like there was some legacy thinking going on. So hopefully this will help to resolve those interpretations, because at the end of the day, the federal NAGPRA is not contained in 36 CFR 79. It's not a museum law. It's in the Indian law section of federal law. So we're trying to provide that touchstone to how the law is interpreted. So I know that that was a lot, but just to give you a little bit of context. And Mel, I'm gonna shift it over to you for a couple more quick hits on 275.
Thank you. So some of the other really nice things about 275 that I'm really excited about and really looking forward to doing repatriation through is that the inventory process has changed a little bit. You kind of see that in the use of the word preliminary inventories in AB 275. So now you have an inventory process that I think is a little more fleshed out and that gives tribes a little bit more say in the process explicitly. So the law is fairly, AB 275 is fairly clear that we're going to see updates, not just to inventories that haven't been published yet, but to existing inventories. And I think that's one of the reasons that preliminary inventories was used. And so there is a deadline for these of January 1st, 2022, which I think is very feasible depending on how this process goes. A couple of the things that I really like about this newer process is that there's a clear requirement to check in with tribes before you start doing any handling of these collections, so that tribes can express what their preferences are for treatment and for identification. I've seen a lot of museum processes where there's a lot of handling or preliminary identification, and they kind of wait until the end to reach out to tribes. So this flips that to include tribes from the very beginning, because often tribal identification processes are very straightforward, but also reflect appropriate ways to treat these very important ancestors and cultural items. And some of the other options are to more explicitly include this requirement to be respectful and to follow the tribe's preferences for treatment and handling of their ancestors. And so sometimes, if this means minimal handling, there is the option to, example, set the minimum number of individuals at once so that you can avoid that excessive handling. And I know that was something that I was really happy to have in this bill, because that has been a big issue. And another reason that these inventories are called preliminary is that they don't get finalized until they make it to the Heritage Commission and tribes have had a chance to say, yes, I agree with that inventory. Because that's been something that I've seen in a lot of the notices and inventories, is that tribal identifications may not be reflected in them, or that tribes may not agree with the decisions that were made. And there's never a chance in that process for tribes to flag those inventories as, yes, this is a good inventory, we completely support it, or no, we don't agree with this inventory. And so now there is that tribal voice in this process, and the opportunity for tribes to say, yes, you know, we agree with the determinations here. So I am super excited as to see how that works out in real time, and for all of these inventories. A couple of the other things that are kind of embedded in this inventory and summary process, and I think Courtney touched on this, is the weight that is given to tribal identifications. I think one of the big things that I really like seeing in here that has been a point of contention for so long is the common sense statement that everything from a burial site may be a funerary object, and that that's a reasonable identification to make. And that similarly, if tribes want to say, hey, this is a sacred site, you know, and therefore we treat items from the site because of this dedication as sacred, that ability to make these categorical identifications of cultural items is more supported in AB 275. So I'm really excited to see that. I think that will make the repatriation process go much more smoothly and reflect tribal values a lot more. And one of the things that I was kind of curious about and was hoping to talk to a lot of the lawyers and people who probably have a better understanding than me during this panel is that is the applicability of AB 275. So I know I really like the Gloria bill, and I like the way that the direction that the new UC repatriation policy is going, but that's kind of just the UC system. What about the CSUs? What about all the state agencies? What about everyone else? And my tentative understanding, everyone else who's on the panel, please correct me if I'm wrong, that maybe AB 275 is all of California. Now we have something consistent that's for all of California.
Hey, Mel, one thing I wanted to, and Courtney, maybe just to highlight and just to go off from what you just said, Melody, is that the CSU system has to also create those liaison positions. Do you or Courtney maybe want to speak to that just quickly? Because I think that's a significant shift For the last few years, we've been talking explicitly about the UC system and getting them into compliance. And now we're also talking about CSUs, who I think have sort of been off the hook for a while.
Courtney, can I ask you to chime in if I'm the only one?
Sure. I mean, I don't know that I have a whole lot to add, except that I understand this was really important to Assemblymember Ramos, kind of get these liaisons in place, and definitely to do something that was more statewide and consistent and applicable and build the relationships. So yes, I think it's important that there are these collections, there are these ancestors in so many different places, and to be able to have a place to go to is really important. So I think it's really great when we can take something from an executive order and then put it into statute, and it kind of can live on beyond any particular governor or administration. So I think it's a real positive, and something that I'm not sure a lot of people realize was actually part of this bill.
Yeah, and that was something that we had really pushed for a long time, because we've seen with a lot of state agencies whose processes have improved, that tribal liaisons have really been key to that, because they can navigate those internal processes and bureaucracies of that agency and really identify, shepherd these tribal concerns through and really lead to better processes. Because they have the bandwidth for that at that agency. So I think the lack of those at the UCs and the CSUs has been part of why we haven't been seeing the repatriation outcomes that we want. I think that this new policy will be helpful, but I think having tribal liaisons there to help get things going and to help fill the gaps will be a big part of getting and keeping that momentum for repatriation. So really excited about that, and hoping that those positions get up and running quickly.
And I just want to add to that, Mel, is that I think the hope is not to just have it be like an add-on to someone's already existing role, right? That they're tribal liaison plus 5 different things is what they do. To really make that a standalone position, to have that elevated within the executive branch with the governmental affairs people, to really make that a professionalized role of relationship building. I think that that's part of the intent behind it.
Yes, exactly. Where I've seen tribal liaisons be successful is where they're in a standalone role, when it's just adding someone else, another title to someone else's position. When they already are full-time and probably already have too many titles, then doesn't really do a whole lot.
And wouldn't it be great if we have a lot of tribal liaisons?
Yes. But Courtney, did you want to go over AB 168 before we jumped into before we turn it over to Lourdes for the system one?
I can do that. I think Michele also maybe at some point wanted to do a quick hit on AB 2836, but I can do it on, do you want to do a quick hit on?
It's up to you. Would you do you need me? Because I was going to do kind of the introduction, kind of laying the groundwork as to the why and whatnot.
Okay, so, maybe we'll hit that after I do a quick AB 168.
Okay.
Alrighty. So while not repatriation related per se, we wanted to inform you all, since you're here and you're going to be working with this AB 168 Aguilar Curry. It's an urgency bill, and it will become effective immediately. You are all probably aware of all the recent efforts at reform to CEQA. Many of those rollbacks did not go through, but as a result, there have been increased efforts to secure statutory or categorical exemptions from CEQA, and to classify more projects as ministerial, right? Which means it's over the counter, there's no public process, there's no consultation with tribes, potentially no mitigation, no conditions. So an area of policy interest that has come up the last several years is in the increased building of affordable and workplace housing. One bill in particular was SB 35 Wiener from San Francisco that created a ministerial framework for certain multifamily housing, focusing on objective planning criteria and design and objective design review criteria. And that bill had an exception for listed historic structures, but left out AB 52 tribal cultural resources entirely. Claimed it was an oversight, but it certainly has become an issue relative to the Berkeley Shell Mound site and the campaign that's going on there to try and protect that resource that's now being litigated at the Court of Appeals right now. So in that case, they're trying to interpret what does listed historic structures mean? Does that include tribal cultural resource sites? So while some tribal cultural resources such as mounds can qualify as historic structures under NPS Bulletin 16, not all tribal cultural resources, as you know, are listed. And as Julie pointed out this morning, many older register listings don't even really address tribal cultural values. They just deal with archaeological or architectural values. So under AB 168, a project will not be eligible for streamlining if a site is a tribal cultural resource that's on a register list, if the local government and the tribe do not agree that no potential TCR would be affected, or if the local government and the tribe do not document an enforceable agreement on methods, measures, and conditions to treat TCRs. So it's kind of a complicated bill. It's a complicated framework that got set up by SB 35, but there's three important takeouts for the THPOs. Number one, it adds tribal lists to the lists of registers that can provide exemptions. So this, I think, is the first time in California law that formally recognizes tribal register lists. Kind of a big deal. And it makes the development of tribal historic property lists and inventories, I think, even more important and relevant and really self-directed to the tribes. So I think it's a big opportunity. May seem like a big task, but I think there could be a lot of rewards for tribes taking a hold of that, which of course they are authorized to do under the authorities that create THPOs. Number two, it creates a scoping consultation process outside of either the planning, SB 18, or the CEQA AB 52 processes that requires consultation between the local government and tribes. So this really can expand the opportunities for tribal input. And if it is cloned onto other efforts of streamlining, I think it could really expand the inputs for tribes to get in truly early. As we all know, not all damage to these kinds of places happen through a discretionary CEQA process. There are ministerial projects that maybe shouldn't be ministerial that impact these sites. And this could be a way, if this is replicated moving forward, to really help get at some of those. And the third thing is it requires an annual report from local governments to include information on the progress of the city or the county in amending its general plan or local open space elements in compliance with SB 18. Now, I wish we'd included this reporting thing 20 years ago when we did SB 18. So this is kind of a good thing to have because many jurisdictions have updated their general plans, but some haven't and some did, but they really didn't do SB 18 on it. And streamlining is only going to work if it's based off of good planning principles and first-tier environmental impact reports that include tribal values. So hopefully we've excited you a little bit to take a look at this bill and to see what how you might be able to use it, particularly in, it'll be in more urban areas, but I think it's a really good step and it might be something that we can use to replicate in other contexts. So thank you, Mel.
And for most of these subjects, we're going to break into Q&A afterward because there's a big role for the Heritage Commission in AB 275. Just saw Patty's question, AB 168 is the name of the bill. Sorry. The lovely thing about pop-up chat, because there's a big role for the Heritage Commission, we wanted to wait and give Laura and Merri a chance to really talk about that before we break into the Q&A for AB 275. So at this point, we're going to hand it off to Lourdes to talk about the system-wide UC repatriation policy and where it's at.
All right. Thank you again for inviting me and others from the work group to talk about our UC policy. I'm very excited about the direction we're going, and as you know, we've been trying to make this a new day, for a while now, and some of these efforts will definitely continue. A lot of these efforts, maybe most of the effort, it's like one thing is what's in the words and the other things are where the relationships take us. And I think that's what's most exciting for us. So I was asked to sort of give a brief overview of what the process was for putting together this policy. Merri mentioned that she sits on the President's Native American Advisory Council, which was convened in 2016 to advise the UC president on a variety of Native American issues as they relate to UC, including like student retention, campus environment, even staff issues, and of course, NAGPRA. From the PNAC, a work group was selected of 4 members from the PNAC, and then the Academic Senate selected 4 other members to help serve on a policy to advise the university on rewriting the system-wide policy. We spent many hours on this. Want to acknowledge, that these members were all volunteers. We reimbursed travel and that kind of thing only, but the rest their time was really just something that they dedicated out of the goodness of their hearts, and it's great, to have that kind of support. I miss them. It was a good way to sort of touch in and say, do we have a good reality check here? I'm going to name them because they deserve to be named here. So we had, as Dino Beltran, who I mentioned earlier, from Coy Nation of Northern California, Val Lopez from the Amamutsan tribe, tribal chair, Mark Macaro, tribal chair of the Pechanga Band of Luiseño Indians, Desiree Martinez, principal archaeologist of Kongstone Resource Management, served for most of the time and gave us much needed feedback. She had to step away, I think maybe in the last 2 or 3 months from that role, but she gave us a lot of time, and I want to recognize that. Carol Goldberg, who is also with us today, distinguished professor at UCLA. Amy Lone Tree, who's associate professor of history at UC Santa Cruz. Beth Piatote, associate professor of Native American Studies at UC Berkeley, and Angela Riley, professor of law at UCLA. So the last 4 that I mentioned are the ones that were selected by the Academic Senate, and I wanted to make sure that like these are all people who there, as Laura said, there was no sides. These are all people who were very dedicated to the cause. And so one of the first things that we did in the process was we established principles, and we talked a lot about the priorities of what the policy would be. And so that's why we focused on developing a policy that would promote repatriation, transparency, oversight, proper care of the cultural items, including the human remains, and effective consultations. UC reviewed all of the comments and consulted with the work group on the comments, and the UC staff, that's myself and Tim, as I mentioned, included, and others at UC, we helped to do the heavy lifting of writing the language of the policy, but we shared it with the work group for review, edits, and comments. So policy status. So I want to give you a brief overview of, the entire effort. So August 19th, we distributed the first draft of the policy to all the tribal communities and to UC communities, and received feedback from those. Then in January and February of 2020, we held 4 public work sessions, which were mentioned earlier, across the state. And we released a second version of the policy based on the comments that we had received from the August version of that. Then in April 2020, we distributed a third version of the policy. And we also received many, many written comments from that, and conducted many phone consultations on that version. And finally, on July 24th, we released an interim policy, and we released it as interim to allow tribes additional time to comment, especially, what that was right, around the time that COVID was hitting, and tribes were hit particularly hard. So we recognized that we were asked to delay the implementation, not the implementation, but the release of the final policy, and so we did. So the comment period is now open through November 15th of 2020. Final issuance is expected to take place by December 31st. But I want you to know that the old policy has been replaced by this interim policy. So this interim policy is in effect. It's not like we are still under the old policy. And you can find Word and PDF versions of the policy, appendices, and all the various versions, including red lines, at our website. And you can continue to submit comments to us through November 15th at rpac@ucop.edu, or feel free to also submit a request for a phone consultation. So I'm going to go over really quickly some of the key highlights from the policy. We also have on the website a more complete list of some of the highlights of the policy as well. So as I mentioned, we wanted to make sure that repatriation was the fundamental objective and value that undergirds the entire policy. And there's some other principles that are included in the policy that also undergird the policy, and that was done in coordination with the work group, and we intended to capture all the things that were truly important, and so that when we did have these questions about and ambiguities, that we would think back on the principles. Importantly, one of the things that we did in those principles is that we acknowledged UC's roles in the acquisition of human remains and cultural items. That's something that I think had never been done before. And when President Napolitano issued the policy in July, she also sent out a letter of apology. So the policy also includes a reconstitution of the committees that has equal representation from UC and Native Americans. And this is of course, in compliance with CalNAGPRA, with the revised CalNAGPRA. Provost Brown, who chaired the work group, was a little bit surprised about the lack of an active role for the committees, that we would only convene them when we had something to deal with, and maybe a whole year could go by in some cases. And he wanted to make sure that there was a more active role for the committee. The committees will be making recommendations to the chancellors and to the presidents, will provide oversight of all activities, And we describe the procedures in the policy. And we also have clear reporting from the campus to the committees and to the president and the chancellors of various aspects of the policy. And that's twice a year reporting. We are happy that we have a much more enhanced consultation section about what it means to truly meaningfully have consultations. We promote the relationships, the transparency, the respect, and establish expectations and communications at certain points. So the policy and the flowcharts provide key areas where we are required to have some communication with the tribes. And I think that that's really key, because what we heard time and time again as we went through the state was that there was often they didn't hear back, you know, and so we want to make sure that there's clear communication points and that the tribes are allowed to present their materials, attend committee meetings, add to the committee, to whatever is presented to the committee, that they get to review all that and that they get to add their own if they want to. So that's, we thought that was really key. We have flowcharts that are really long, and we plan to have an easier sort of walkthrough maybe on our web page. Over the next year, we can develop something. But the flowchart is both externally and internally facing, and I'll tell you why. Because we want to make sure that there's transparency as to what our policy, what our process will be. But it's also meant to be a guide for the repatriation coordinators at all our campuses about what the process should be. That's part of creating some consistency. And that's why it's very long, because we try to cover the entire process. Of course, we will need to update it now because of AB 275, and we haven't done that yet. There is an opportunity for appeals and complaints to go to the Office of the President if they're not resolved at the campus level. That was something that we had revised based on the feedback that we received. And I already talked about the last one. Okay, so research use. We essentially, research is not going to be allowed unless you have explicit tribal approvals. And we also tightened all the loan procedures, controls, and requirements in this last iteration of the policy. And cultural affiliation, as you know, we've heard about 275, we need to go back and look at it again. But the interim policy clarifies that we must respect and value the oral history and other tribal evidence, and that sometimes that may be the only line of evidence available, and we will need to go back and incorporate 275. So one of the other things that we heard from our visits across the state was that the tribes wanted a way to facilitate the process when items were at more than one campus. And so we've clarified that there could be a single request, and that we at UC will internally coordinate that. Lastly, there's, well, two more things. There's the repatriation plans that are required by the policy. There is a requirement for reevaluation of all the CUI. Of course, that's also going to be done once the list of California Indian tribes is released. It's required by CalNEGRA. There are clear deadlines, reporting, and notices. We also require that the campuses perform outreach to tribes, and to, in some cases where we have items where there are other controlling agencies, that we reach out to those controlling agencies as well on a regular basis. And importantly, also that they include budgets and timelines. I think that this will be an important thing for the UC leadership to know what the costs are, and allocate those costs accordingly. And then we also enhanced the report, how we will assess the campuses, because we've heard many times that there are likely other items at our campuses that we don't even know about and that we should perform assessments. And so that's written into the policy as well as the whistleblower hotline for anyone to report things. That's a very brief, I didn't want to take too much time, but I did want to make sure that we hit on some of the highlights on our policy. Stop sharing now.
Thank you, Lourdes.
You're welcome.
Michele, we were wondering if you were available to go over the Gloria bill as well, since I know that prompted the updates and revisions to the UC system-wide policy.
Yes, I do. I am ready now. I do apologize for this morning. I tried to tell the court I was unavailable, but sometimes when the judge decides, I don't have a choice. So, but thank you all for inviting me to participate on the panel this morning. It's been, a real pleasure to work with, the Pechanga team and Todd Gloria's team on some really groundbreaking changes, I think, in the UC system that became necessary. I think we all kind of know the history of CalNAHC here, as Laura mentioned at the beginning when she introduced herself, that she was one of the technical advisors on the original CalNAHC bill in 2001, which really was, the result of a failure by UC campuses at the time to comply with the federal NAGPRA. So that was the first time we saw tribes and advocates, saying we need to do better, right? And then pretty much fast forward to 2008 when Berkeley dismantled its NAGPRA unit, there was a lot of upset by tribes and pushback, and that resulted in a hearing again in front of the state legislature about why the step was taken. And so in 2008 we saw more eyes on the UC system. But it wasn't until later in 2017, 2018, when Pechanga and some other tribes were seeking a large repatriation claim, including human remains and ancestral funerary objects in possession of UC Berkeley. And not to focus so much about just Berkeley, but it became really clear that our issues and our troubles with repatriation were not unique, and so really trying to think about how can we change the system, right? We saw very clearly that there was a systemic problem in the UC campuses, largely due to the fact that there was no consistent policy that the campuses could really be held to, right? And so, we saw very differing repatriation rates. UCLA pretty much repatriated, all of their Native American human remains, whereas Berkeley still has, the second largest collection of Native American human remains in the United States. So, trying to think about how do we address the issues that tribes have been complaining about, everything from lack of transparency to no communication, years in between filing a claim and actually seeing some movement, tribes often getting their claims rejected. And so we were kind of looking at why is this happening? And, looking at the composition of the committees making these decisions. You had folks with, really vested interests in not repatriating. So osteologists and other disciplines really looking at bones and what that can they tell us. And, that's a direct conflict, with the tribe's rights. It's a human right to repatriate their ancestors. So we have a real big conflict, and especially at the time, I think that 2001 policy of the UC that came out, really, yeah, repatriation is important, but this is an educational facility. And so it really was, trying to change the view of the ancestors as specimens. So, really thinking about what kind of folks are the ones that are best suited for this kind of decision making should be people that actually work with human beings, like contemporary Native Americans, right? So they're not just the deceased remnants of a people, just trying to remember the humanity of what we're doing. So looking at disciplines that recognize that, right? So kind of narrowing the pool, right, to keep out that's not the right word, but to make sure we have, the folks that are looking at the best interest. Congress already has stated its policy. The state of California has stated its policy, and that is repatriation. So how do we get there? We also felt that, people needed to have experience, right? So not just what degree do you have, but where is it? Where is your expertise? Because my understanding is a lot of the collections we have at UC Systems are California Indians. There might be, ancestors from other parts of the country, but a lot of the collections I understand are California Indian. So really kind of thinking about what does that mean? And that dovetails into the issue with cultural affiliation. And, I'm so excited to see the definition of traditional tribal knowledge now in California law, because that's one of the things that we fought against, right? Tribes, when they are making cultural affiliation claims, they're bringing oral tradition and, religion and those things that aren't tangible, like bones, right? And so claims get denied because, well, the bones tell us one thing and your oral tradition tells us something else, and so how do you weigh that evidence? What if there is no, osteological evidence or biological evidence and all you have is oral tradition? There are, some institutions that say, well, I'm sorry, that's just your oral tradition. It's not fact. So trying to understand and try to balance that. Because, one of the other key issues we wanted to address is the culturally unaffiliated collections that comprise, I think, upwards of two-thirds of Berkeley's collection. And so what that basically means is that as culturally unaffiliated, those remains just sit there, right? And so we really need to go back and look at that. Right? We need to force these institutions to go back and to actually consult with tribes. One of the responses we got from Berkeley on our claim was, well, we sent you guys notices in like 1999, and asked for feedback then, and I'm like, okay, there's so many things wrong with that it should be more. And that was another thing we wanted to build in is, not just one shot. Like this should be a priority, which means if you don't get an answer the first time, you need to keep trying, because these people need to go home where they belong. So kind of thinking about factoring that in as well. So overall, the whole idea of the composition of the committees was trying to find folks with an expertise and a sensitivity to these issues for tribal communities, recognizing that the UC also has a role here. So balancing the composition of the committees with representatives from tribes, as well as from the UC campuses, on both the system-wide and the individual campus committee. So really kind of thinking about, how do we move this forward in a healthy and healing way, and start to repair, some of the issues that we've seen with Berkeley and with some other institutions in California. So, that was really kind of our thought process. What was the big problem, and how do we kind of address some of the things that we felt were mucking up the system, if you will. So, leading into the development of the policy, one of the other things I was asked to speak about today was my thoughts, not just from the work group perspective, but also, from in-house counsel perspective that does this for tribes. So I don't know if you want me to hold those comments and go into the rest of the work group discussion, or.
I know we are having an AB 275 discussion later on with the Heritage Commission, so I don't know if it would make sense to kind of hold it till then. But since we are jumping into like the system-wide policy, actually it probably would make more sense to go into those and then jump into kind of our discussion point for the system.
Okay, so I thought, working with just a few thoughts on the work group, I think that it was a great forum to bring together some expertise from different areas. We had UC folks that are policy writers, and, I know Lourdes and Tim had an amazing learning curve that they got thrown when this, became reality for them. And that's a huge accomplishment. We also, as drafters, we recognize that this is a new thing for the university. The university is not an entity that typically consults and does this kind of role. So we know that there's been an education, on that process for the UC folks. So just kind of recognizing that's where we were starting from. And so, but I think, there was a lot of listening. I think that the tribal representation allowed, the UC folks to really understand, in real time what the issues were that tribes were facing. And so, being able to talk that through and being able to, read language and have not just the view of the UC, but also, the tribes that have worked through this, really being able to think, is this going to make the process easier? Is it going to, create more bureaucracy and those kinds of things? So I think that the group did come with the right heart and with the right intention. And that is what I heard throughout the whole work group experience. My thoughts on the policy itself, first and foremost, it's a massive change over what tribes had, before in the 2001 policy. We have some certainty, we have clear responsibilities and accountability. Tribes know where to go for dispute resolution, and there's involvement now. Whereas in a lot of, and I know with our claim, for example, we were never invited to come and sit down and talk to the committee and explain the oral tradition. And so, making sure that tribes are actually an active participant in these processes was one of the things that really was foremost on my agenda. And I think, just kind of zooming out, both as a work group participant and, someone who does this practice for the tribe, some of my concerns, and I don't know that this is a shock. One, I do feel that maybe, in this next interim time, while we're looking at the interim policy and figuring out what the final should be, I would like to see if we can look at something that's a little less technical. I would like to make sure that, for tribes who haven't had a chance to read it, read through it and make sure that, like, if you had an active claim, would you be able to get it through, right? Does it make sense to you? That's one of my things, as a drafter, I do code drafting frequently, and, drafting in a vacuum is one thing, but when you actually put wheels and it gets used, that's when you realize, okay, wait, maybe we need to adjust this thing or that thing. And I feel like that's probably going to happen with this policy. Just to be honest, I think that it's long, it's technical. I think there's going to be some issues. But again, it is a huge improvement over where we started. So those are kind of things that I would like, to consider thinking about and asking, the tribes that are listening today, take a look at the policy if you haven't, and really think about, its real world application and what it means for you. How would this help a claim that maybe was stuck for you? How could it have expedited it? That's the thing I'm really looking for is the practical obstacles that we might face with a policy that's, I can't remember what it ended up being, 30 some pages with flowcharts. So that's really one of my main concerns, is making sure it's really accessible across the board to all tribes. But those are my main comments. I'm happy to answer any questions or, jump in if there's other areas I can add to.
Carol, I was wondering if we could hear from you on your thoughts as a member of the working group as well, before we started going to some of the questions and discussion points.
Sure. Thank you very much, Melody. And thank you to the entire group for including me in this program. There are a couple of points that I would want to make to elaborate on things that Lourdes said. One about the process. She made reference to the working sessions that the group undertook. And I just want to underscore that these involve both very intensive scrutiny of campus processes, looking at everything from the facilities to the staffing, to the care or lack of care being provided, especially to the ancestors. And then in addition to the scrutiny of the campus processes, the public facing opportunities for us to hear from folks like yourselves. And of course, I recognize many of you having participated, as well as exchanges with the commission. We did spend a lot of time going through, in addition, the written comments that were obtained. I don't think anybody who volunteered to be on this working group, whether you were a tribal representative or an academic senate representative, really understood what we were doing when we said, yes, we would serve. It grew way beyond what we might have originally imagined, but there was good reason for it to grow. And those of us who care deeply about the university's obligations were, you know, we were ready to jump in for it because we knew that it would improve the policy. The second thing I want to do is just say something about what I see as the most significant transformations of the policy. Lourdes has gone through it, and there are many improvements. But from a personal perspective, having served on the system-wide committee, having worked very closely with Wendy, Teeter, and others at UCLA at the campus level, I see two massive improvements that are structural, that will help give life to all the other provisions that improve things like consultation or definitions of preponderance and so on. So the two big structural changes that I want to emphasize, one is that under the prior policy, if a campus decided that there was no cultural affiliation or no basis for repatriation, that was a final decision. There was no way to appeal to the system-wide body. On the other hand, if the campus decided that it was going to find cultural affiliation or was going to authorize repatriation, there was at that point the opportunity to appeal to the system-wide committee. So as a member of the system-wide committee, I found myself regularly in the position of defending UCLA's decisions in favor of repatriation. And the campuses that opposed it, they never had to defend their decisions because there was no appeal. The new policy completely reverses this arrangement. And that is a huge structural change. At this point, if a campus like UCLA, which at this point has very little left to do with repatriation, but there is some, if a campus like UCLA decides in favor of repatriation, that is a final decision. There's no appeal. Whereas if a campus, I'll just pull one out of the air, Berkeley, let's say, chooses not to repatriate, that is subject to appeal to the system-wide committee. So that is a huge change right off the bat. The second structural change that is going to have such a powerful impact is the one mandated by the Gloria Bill as to the composition of these committees, both at the campus level and at the system-wide level. I can tell you that when I was serving on the system-wide committee, there was a representative from, I'll just name it. There have been changes there, so I don't mean to suggest this is currently the way things operate, but at the time, the UC Davis representative was an individual who was an archaeologist who believed himself to be representing the archaeologist's interests. He said outright in the meeting, I am an interest group. There was no accountability to anything at the campus level that was a repatriation committee of any kind. Whereas I at UCLA served as chair of a committee that reviewed very carefully all of our repatriation proposals before we made a decision. And as a representative on the system-wide committee, I viewed myself as accountable to my colleagues at UCLA. So there was an immense amount of variation from campus to campus, no expectation of tribal voice, either at the campus level or in the representation of a campus at the system-wide level. That has been completely altered, not only, of course, through the Gloria Bill, but also through the implementation of those requirements in the UC policy. And I think, you know, the written policy is very important. The statements about and provisions for consultation, the statements and provisions for preponderance of the evidence and demonstration of cultural affiliation, but the personnel who are reviewing those are very important also. And I think this new policy creates an improvement. And I said there were only going to be two, but I'll mention one third structural improvement, which is that there is a provision for complaints by tribes if the process is not being adhered to properly. And, you know, I think that's going to be a huge improvement also. Not that you want to be interrupting these processes regularly, because that will slow them down. But if they're not proceeding in accordance with the system-wide policy, there ought to be a way to complain about it, and the new policy provides for that. So I guess, you know, I take to heart what Michele has said about the importance of the policy being workable for tribes. We need to make sure that that is the case. But that said, and that process necessarily to be undertaken, I want to say that there are some very significant structural improvements in this policy, as well as the substantive ones that Lourdes has explained.
Thank you, Carol. That's really good to hear. I think especially some of the structural issues that were impediments before that are getting fixed, that you didn't realize were there until you tried to navigate the system. So just a quick note, I believe we are breaking at 11:30 for lunch, and we'll be coming back at 12:30 and picking back up. So this is just the first half. Thank you to Lourdes, Michele, and Carol for that excellent summary of how we kind of got here with the process. I think one of the things that I wanted to emphasize is that it is an interim policy, and originally we pre-AB 275, you know, it was still open for additional tribal comment and revision, especially now that we have AB 275. I think we were curious about what the new timeline is for incorporating AB 275 into the policy and how it's going to be incorporated. Is there going to be another round of revisions and tribal comment? And I was wondering if you could speak to that, Lourdes.
Well, 275 is brand new.
Yeah.
We have a lot to review, and we need to make sure that there is consistency across, you know, the whole policy with 275, with the rest of CalNAGBRA, and with federal NAGBRA. And we will be reviewing that. We hope to incorporate all those changes by the end of December. Comments are due November 15th. So I think that the feedback that we receive from tribes till then is what we really need, you know, now on the incorporation of 275. And I think, you know, we wouldn't have time for the system-wide sort of working sessions, et cetera, if we want to implement by December 31st. And we need to implement by December 31st. We cannot miss another deadline as we did last time. So I think we need to implement by January 1st. So that's the intent, but we need to review, to be honest.
Thank you. I appreciate you addressing that when there's been so little time to really chew on that. And maybe that's something that we can discuss more during the panel too, because I think we're all kind of excited to see how AB 275 gets implemented. I know Dina wasn't able to comment before. I was wondering if maybe your audio is working now, or if you were interested in commenting on the process as a working group member, Dina.
Well, good day, everybody. Lourdes, I'm honored to have you ask me to be a part of this. You know, I've reviewed I just got the call the other day as I talked to her on another subject to join today. And after I reviewed the policy, really the only thing I think you've already encompassed there, Melody. I'm really concerned about the inclusion of AB 275. I really feel it looks like it will accompany this policy in a solid manner. Mm-hmm. You know, during the whole process, as we were trying to be so inclusive of all possible tribes, especially the unrecognized tribes, that plight, I know my tribe was fairly unrecognized for years and years and years. So to have the inclusion of the unrecognized tribe was just beautiful. And I really want to thank Desiree Martinez for everything that she has done. She has really been a huge, huge person in this, and her passion. I just want to thank her for that. But there's one thing that is mentioned in AB 275 that I didn't push much, but I see that there could be a problem. And that is, unfortunately, it's a political issue. It could be a political issue, and that is putting UC in the middle of a potential fight between an individual and a tribe. So I am aware of a situation right now to where, and we should go on to this later, but I'll mention it now that you chew on it for lunch, and then we'll come back. But there is a situation where there is a spiritual person who has connection lineally to some artifacts, namely a big head dance outfit. Several of them, the whole outfit is down at UC Berkeley. So what we need to do is we need to make sure that that person who has been disenfranchised and disenrolled by his tribe is somehow involved and not just under prioritized just because he's an individual. It's also unusual for a Native American who is a spiritual person. I am a roundhouse person. So when we're trying to include policy around these ways, sometimes our words have to match those kinds of situations, like religion, religious, those kinds of things. It's unusual to do that for some of these spiritual ways. But I'm just going to throw that out there, and that's all I really have, and we'll talk about that later. So thank you, and it's good to see everybody out here. Boy, this is what a turnout. Let's talk to you in about an hour.
Thank you, Dino.
Thank you. So I know that we are scheduled to break at 11:30, and I wanted to stick to that because we've got all the time. I'm thinking that we'll probably continue to do some of the system-wide policy Q&A when we get back from lunch, and then move on to the campuses and the Heritage Commission discussion. We do still have a few minutes left, and I was hoping to kind of talk through, expand on our earlier discussion about AB 275 and how it gets implemented in the policy, in the current policy, because I know we have deadlines we have to keep, but there's also a process for revision in the interim policy that's under discussion right now. Do you kind of foresee a lot of the AB 275 details getting ironed out in a future revision, perhaps?
Yeah, that's very possible. You know, we need to consult with NAHC. NAHC needs to do a lot of work, you know, ahead of that even. So I do think that it is possible that we can iron out some of these things in a future revision. That may be what we have to do, but we will try to incorporate, I think, what we can.
Yeah. Just curious about how that ends up working out. A lot of our other discussion points kind of focus on the committees and how that committee involvement can really shape the development of policies. So that's something I know we were hoping to talk about a lot more after we get back from lunch. And as a reminder, we are opening up for Q&A now. So if you have any questions, it's great to submit them during the lunch break or think about them then, because we are taking audience questions now too. It's not just panelist discussion. So I'll turn it over to Shasta to do her discussion of the lunch break and everything else.
Leave it to me to talk about food. I think I've given myself a reputation. I have to make just a personal comment that, Courtney, you better watch out, because if I see you in public with that necklace on, I'm going to push you down and take it. And I've got, see, as you can see, I don't like turquoise at all, you know, not even a little bit. But yeah, that's gorgeous. And also women, it's always a good idea to think about your jewelry in terms of how it can help defend you if somebody tries to, like, you know, beat on you. So that's why I wear the fat rings. It's like extra damage. And I think that necklace might work. I was seeing Mary's like, I have no rings. So just count on me, Mary. I'll always be there. And just so you know, I've never hit anybody in my life. I think I said that yesterday, except my sister, and she doesn't count. So anyhow, it's lunchtime. So everybody go and give yourself a chance to relax. And this is a heavy duty topic, and we're really looking forward to your questions in the second half. So, and Tom actually in the chat has just said to me that he can make himself available during lunch if people want to ask him questions about Berkeley. So you should, I'm going to have our break slide up, but you guys should still be able to chat if you want to during the break. So everybody go and enjoy yourself for the next hour, and we will see you back at 12:30.